Right, good evening, everyone. Thank you all for joining us for the next instalment of our webinar series. Just before I introduce tonight's one, I thought I'd just mention last week's one in case anyone missed it. But we had Melinda talking about taking control, all things off-rolling, exclusions, your right to a mainstream education. What if the school I want is full, for example. That is on the YouTube channel, and that was a recorded one. So if you did miss that one, please do go on the YouTube channel to watch that. We've also got signposting webinar, which introduced a number of sort of charities and various people to use. Do check that out as well. That's also on the YouTube channel. But up tonight, we've got Richard Nettleton, who's one of the solicitors at practice, and he is talking to you all about non-SEN tribunal remedies. I think Richard is now ready to go his PowerPoint. What we're going to do is Richard's going to go through his PowerPoint, and then there'll be a Q&A session at the end of the PowerPoint where any questions that you put in, I can ask Richard live, and he can give you a direct answer to. We'll also sort of cover what's sort of going to come next, because we've still got 2 more installments to come in the webinar series. So Richard, I'll hand it over to you now if you're ready to go.
I am, James. Thank you very much. Hopefully my screen's shared and you can see that.
I can see it, yeah.
Perfect. Lovely stuff. Good evening, everyone. Thank you very much for joining us on another webinar, and hello to everyone who's watching this on pre-recorded. As James introduced me, I'm Richard Nettleton, and I'm a solicitor here at SEN Legal. I will be covering tonight non-SEN tribunal remedies. Just the boilerplate thing to start off with, or boilerplate information that material contained in this presentation is for personal use only. It is not to be reproduced, distributed, or relied upon. Obviously, please seek specific legal advice as to your individual case. I covered judicial review briefly in this presentation. That is a big point you should seek specific legal advice on before you embark on that. It is not the same as putting an appeal into the SEN tribunal, which I'll cover briefly in this presentation. Also a point just for the Q&As, please ask in the Q&As questions. There's solicitors behind the scenes answering some of those questions. And James will put some of the questions to me live that are from a common theme. There's a bit of an issue with the 1+ that when you're typing an answer, it seems to wipe when a 1+ has happened, when it's been upvoted. So if you are able to refrain from pressing the 1+, we'll try and pick out the common themes from there, but normally we'll be able to answer more questions that way. So what I'll be covering in this presentation is the various topics that I'll read through in a second. They are the most common ones that we feel parents are going to run into. It's not an exhaustive list, and they are very broad overviews of each topic. But again, more information that can be found in some of our newsletters and other various online sources, but it should at least give you a flavour for each one of them, and the potential use for it that will be specific to your own situation. So I'll be covering mediation, local authority complaints procedure and local government ombudsman, NHS complaints procedure and parliamentary and health service ombudsman, healthcare and professionals council, Secretary of State for Education and Ofsted. I'll then go into pre-action protocol, which is normally the non-tribunal remedy that most parents end up involving it or having experience of, and then judicial review. Important, while DDC can be dealt with in the county court against local authorities, and that is actually covered by a separate presentation, so I'm not intending to go into that. That presentation is available on our website. It covers disability discrimination in a whole, in sort of a whole hour with questions. So if that's what you've come here for, have a look at that presentation, as it's very detailed. So starting the presentation off with mediation, the one that I think divides parents across the SEN community about its effectiveness. What is mediation? Mediation is free and voluntary, and it's an alternative dispute resolution that attempts to give you an opportunity to try and settle the dispute with the local authority before you have to get to an appeal or putting appeal into the SEN tribunal. It's normally in the form of a meeting with the LA and an independent mediator who will try and help you reach an agreement on the areas of dispute that you've got. Now, that can be wide ranging from the local authority didn't undertake the HC needs assessment to the actual content of the plan to ceasing the plan. The topics are broad, and the mediators should be able to sort of help facilitate a meeting with yourself and somebody who is able to reach decision from the local authority, which I'll cover in a slide in a moment. However, it is important to note that you don't have to attend mediation. You don't have to physically attend the meetings if you just want to go straight to appeal. You can just request your certificate and move on. However, some parents want to have that final chance, and rightly so. It's at the end of the day, it's your child at the centre of this, to be able to look at another individual and say, actually, these are the issues. Can we resolve this without having to use the tribunal? Mediation contact details are provided with every right of appeal that is issued, and depending on what decision was issued, the most common ones you're going to run into are Regulation 5, which is decision not to undertake an EHC needs assessment; Regulation 10, decision not to issue an EHCP; Regulation 14, issuing of a final EHCP following the EHC needs assessment process; Regulation 22, amending the EHCP after annual review; and Regulation 31, ceasing to maintain an EHCP. So those mediation details need to be provided to you. And if they're not, most local authorities now do. We occasionally bump into one of the more northern local authorities that are missing this information from their decision letters, but majority of local authorities now have a standard sheet that they produce, or it's actually on the decision letter itself about how you contact and who that is. It's normally covered by Global Mediation, Kids Mediation, one of the sort of big companies. So one of the, I suppose, benefits of mediation, which I alluded to, is the fact that decisions a lot of the time in cases can be reached without any conversation between parents and LA officers. LA officers can change quite rapidly during the process, and even week by week, of who's handling your child's case. So mediation provides that opportunity to have a frank conversations about the issues involved. Also, if you're looking to appeal, again, I'm trying not to focus on the appeal, but it obviously interlinks. Mediation certificate can be used to extend your right to appeal by an extra month, providing the mediation company is contacted before your initial 2-month right to appeal ends. So as long as you contact mediation towards the end of that right to appeal, you can then use the mediation certificate or the time mediation to give you additional time. This can help preparation for your appeal and gather more evidence if that is required. If you want to mediate, the LA cannot refuse this. That's Regulation 36 of the SEN Regulations 2014, and it must be arranged within 30 days. I say that's non-negotiable. I have seen occasional ones where it's gone over that, and ultimately that is again a pre-action judicial review issue. But most local authorities will get that done within 30 days because the mediation company will be chasing them. And the LA cannot refuse to mediate, or, which is the classic example we see, try and arrange some other meeting. So reference to a common tactic to have some meeting outside of the mediation itself. It's the mediation or nothing. I wouldn't be getting into agreeing side meetings before you have mediation and things like that, because at the end of the day, they're not covered by the same regulations if agreements are reached. If you attend mediation and it goes well and you reach agreement with the local authority, you achieve what you set out to achieve. This agreement needs to be put in writing. That's quite a sort of basic point of mediation. The mediator themselves should do that, but it's important to note, make sure everything that is agreed is noted down. Regulations 42 and 44 of the SEN Regulations 2014 set out the timescales following mediation, depending on what was agreed, and that allows your agreement to be enforced. If the mediation was entered into following a right of appeal, so refusal to undertake EHC needs assessment, content of the appeal, something like that gave you a right of appeal to the tribunal, the agreement can be enforced through pre-action protocol and ultimately judicial review if the local authority, I suppose, renege on such agreement. That's covered by Regulation 42 too, which clearly states that the mediation agreement is to be treated the same as an order of the first tier tribunal. If you enter mediation for other reasons or end up in mediation through whatever suggestion has happened, if it's not covered by a right of appeal, that regulation doesn't cover you, which I know occasionally parents have ended up in that situation. So it's important to enter mediation after a right of appeal. And then the timescales that are set out in 44 for whatever was decided will kick in. I suppose this slide is more about the pitfalls that occasionally happen to parents. And I suppose the regulation you need to quote to overturn that. And again, it's if the LA refuses to do that, you're either going through the complaints procedure or pre-action. But due to the time issues, you're probably going to be in a pre-action situation. So a common one is the local authority not sending a decision maker to the meeting. That's a breach of regulation 37. The person who attends the mediation needs to be able to make a decision on behalf of the local authority. It's no good someone who's a junior officer who then has to keep phoning to make a decision. Whoever it is should have sufficient authority to make that decision. You've then got the LA refuses to attend if X is present. Normally that's ourselves as solicitors who local authorities don't want to have us in attendance. That's likely a breach of regulation 38. There is also a very recent piece of case law on that, which is Kumar versus London Borough of Hillington. It confirms the parent can bring whoever they want to support them during mediation. In that case, it was a solicitor who the local authority were refusing to undertake the mediation with. But again, you can bring whoever you like to mediation, and the local authority are on very dodgy grounds trying to refuse on that basis. If the LA refused to comply with the mediation agreement, again, that's potential breach of regulation 42 and 44, depending on what the timescales are or what was agreed, which will then generate your timescales. If you're reaching agreement with the local authority, and often a lot of times we see this in relation to TA hours in schools, ensure this is part of the agreement is that the plan is going to be amended to put this in. We see it too often that a mediation agreement covers this, as opposed to it going in section F where it should do. If the local authority, you've had the meeting, you set it out and the local authority have said, yes, okay, we're going to put in 25 hours, 32 hours, whatever it is, TA support. If it's section F provision, make sure it is amended in the plan's reissued. While you can enforce mediation agreement, it's better to have it inside the HC plan itself going forward. And I would treat anyone who is not willing to make what I consider a fairly reasonable request with quite a large degree of suspicion. Moving on from mediation, we now come on to the local authority complaints procedure. So while every LA does this slightly differently, they have it on their various websites, all covered by the Local Government Act 1974 that says that this information needs to be contained. You should be able to find it, I say, fairly easily. Some of the local authority websites are a nightmare to navigate, but it has to be on their website. You're normally looking at a two-tier structure. Some local authorities make this more complicated with additional review steps, but realistically speaking, you're looking at tier 1, which is a standard complaint, which is then dealt with. It shouldn't be dealt with by the person you're complaining about. Again, it's too often we see that it is a local authority officer and they investigate themselves, and then surprisingly they come to the conclusion that whatever they did in relation to your particular matter or your particular case was fine and was compliant. That's not appropriate. In no walk of life would you have the person who is the subject of the complaint being the one who is deciding the complaint. If the complaint is not resolved at that initial stage 1 complaint, and again, whatever timescales the local authority put on themselves for the complaint procedure, but they need to be reasonable. It can't be, we'll come back to you in 6 months' time. You're then on to potentially a tier 2 complaint, which is normally dealt with by the monitoring officer or someone from the monitor officer's team. And that's then re-looking at that complaint. Once you've gone through that complaint system, you then have access to the Ombudsman. You have access to the Ombudsman as well if the local authority unduly delay, and I'll cover that in the Ombudsman side in a moment about what they feel is a delay. But you need to go, before you can normally get to the Ombudsman, you have to go through the local authority's complaints procedure. I've noted there again, you shouldn't have the officer who is the subject of the complaint investigating themselves. What you're most likely to be complaining about is breach timescales in relation to EHC needs assessment. Issuing the draft final plan is a fairly common one. Failing to issue a decision following an annual review. Failing to provide provision stated in the EHC plans, section 42 issue. Issues related to transport, which James will cover next week in his presentation, but that comes up a lot about local authorities and refusing to provide X, Y, and Z. And then overall conduct of an LA officer, I keep seeing on social media various stories of LA officers, which I totally believe that's exactly what was said. And ultimately, they're representing the local authority, so there is a professional standard that they should be upholding. And snide remarks and things like this are not suitable, and therefore generate complaint like in every walk of life. In relation to the internal complaints procedure, though, when issues like that I've identified on the previous slide arise, the automatic, I suppose, go-to is normally the complaints procedure, which can interrupt potentially the pre-action stage, which I'll discuss later. Judicial review is a remedy of last resort, and it can be evidenced out that you had alternate routes to be able to deal with that problem, then potentially you can end up with a claim for judicial review failing. Now, education cases require urgency. So I'll take the example of not providing provision under Section 42. A lot of parents go down the route of using the internal complaints procedure to try and resolve that. That, in my world, is an urgent issue that needs a pre-action to get the local authority to comply with the requirements set out by the Children and Families Act. You can come back at a later stage to deal with complaints procedure and things like that, but it can potentially get in the way of the litigious work. But again, I'm conscious not everyone has the available resources to be able to do that. So if that is your situation, the complaints procedure will have to do for that situation. But be cautious, because the amount of time somebody comes to me and they've already got a complaint in, it does restrict what I can do and the advice that I need to provide in relation to how to progress forward what is clearly a statutory breach of whatever it is the local authority are doing. I also remember I was going to say many years ago now, I was at whatever, I think it was a conference, it was some kind of event, and a parent came up to me and was talking to me about the complaints procedure, and they were using it in relation to the tribunal proceedings in respect of the local authority had stopped corresponding with them. They wouldn't return the working document, they wouldn't do things like this, and they were trying to get some movement out of them. The complaints procedure from the local authority is not the correct venue for that. That is through the tribunal itself. If the local authority are not cooperating in a way, providing you documents that you need, such as the working document, which I think we've covered in previous presentations, that's a request for changes, and that's through the tribunal. Again, I'm trying to stay away from tribunal remedies, but you can sit in the LA complaints procedure for what feels like a lifetime of stage 1, stage 2, and your appeal is over by that point. The tribunal, while it is sometimes quite slow in responding to requests for changes, that is the appropriate venue. So all you have to do for requests for changes is email the local authority with what it is that you're proposing to send to the tribunal, or what you're asking the tribunal to do, and allow them 5 working days. If they don't give you a response within 5 working days, then you can go to the tribunal and make the request. If they give you a response and it's not the answer you want, you can still go to the tribunal and make the request. The tribunal will ultimately decide whether they are going to grant whatever it is you're requesting and make an order for it or not. But that's the more appropriate venue, as opposed to using the complaint procedure to try and get local authority officers, tribunal officers to engage with you, because I know firsthand that can be a painful process. Local government and social care ombudsman, who are they? Well, they're the organisation that investigates allegations of maladministration, which have ultimately resulted in an injustice to the complainant. Most council services can be investigated, and education and social services are not exempt. I've seen it before where they've claimed they are, and the Ombudsman won't investigate them. They perform a local authority function, so they are within the scope of that Ombudsman to investigate. If the LGO finds the body investigated acted with fault, which caused the person an injustice, it will recommend a remedy to put things right. LGO remedies are aimed, and I've put it in bold and underlined, aimed at putting the person back in the position they would have been if it was not for the fault. It can also recommend action to avoid similar issues affecting other people, such as reviewing practice and procedures. So it's the classic, you need to have a look about how you conduct EHC needs assessments, how you issue plans, things like that, which if you read LGO decisions, is a very common theme and seems to pop up again and again with the same local authorities. I suppose the reality of the situation is, looking at the LGO complaints, child's education and therapies are apparently, sometimes they could be missed for many years, are apparently only worth a few £100s. The Ombudsman lacks the teeth to do the job that it needs to do. While it might resolve your issue, while it might make the local authority officers think twice when they next come to deal with your case, the actual powers of this organisation need, in my view, a drastic reform, because you can see various stories out there where, moving a bin that was incorrectly placed, or ensuring that that was never placed back near that person again, is dealt with a lot quicker and with a lot more severity than children who have been out of education for severe or significant periods of time, provision not provided, issues like that. So there is an issue with the Ombudsman itself, and the quality of its investigators, I suppose, would be what I'd be flagging with that particular organisation. In relation to the LGO, you must complain within 12 months, becoming aware of the issues. So 12 months from the final decision that the local authority reach, you need to have made that complaint. If you've not had a response within a reasonable time, you can register a complaint with the LGO straight away. So if the local authority just ignore your complaints, you keep getting it out of office, no one's coming back to you responding. Normally, the LGO will say about 12 weeks of no contact is reasonable for them to investigate. And I mean, they have investigated on numerous times before, looking at decisions that are published on their website that show the local authority have just ignored the matter and hoped it would go away. The Ombudsman will step in to begin its investigation. The LGO aims for a complaint to be decided within 26 weeks. There is a little bit of give and take on that, particularly with complex social care issues, but 26 weeks is what they're aiming for. However, again, I'll highlight it's not a quick process. That's 182 days. For anyone just doing the maths, as I said, 26 weeks. That doesn't get you an immediate resolution, particularly if you've just done the tier 1 complaint, you've then done the tier 2, the Ombudsman's tier 3. You can be looking well over 200, 250, coming onto a year's worth of days, depending on how long it is taken. A point to know about SEN tribunal appeals. For years, the Ombudsman has sort of taken a line that they won't investigate an appeal, or they won't investigate issues where an appeal is underway, or that relates to that appeal. Now, this is a very, I think, investigator dependent issue, because there are some decisions out there where the person investigating has actually weighed into that. There is also a judicial review being brought about the Ombudsman doing this exact point. While the Ombudsman is right that it shouldn't be redeciding issues that the tribunal decides, the issues that happen in between an appeal, with conduct by local authority officers or issues that lead up to that appeal, in my view, should be well within the scope to be investigated, because at the end of the day, that is standard conduct. And I believe that is what that JR is looking to do. But obviously we'll do an article on it once, wherever it gets to, as we're watching that one with much interest. But again, the Ombudsman is very investigative specifics. A lot of the time they don't have the legal training that's required, and therefore absolve a breach that shouldn't ever have been absolved, whereas other investigators working for the Ombudsman will be a lot harsher. But again, as there's no professional body for local authority officers, there is very little repercussions for those officers who conduct themselves in a way that they shouldn't have conducted themselves, I suppose, to put it bluntly, or have acted in an unlawful manner, which is a stark contrast to other ombudsmans, particularly even ones that govern solicitors. We have a professional body, we can report to that professional body, and the Ombudsman wouldn't hesitate to do that. And that's, I suppose, one of the key issues for the local government ombudsman. They perform a function in society, but their powers need to be increased. NHS complaints procedure, this is one that we're seeing a lot more parents use, and it's in relation to the issue of non or lack of quantified and specified recommendations in reports from a speech and language therapist and occupational therapist. Now, these professionals know very well when they're commissioned exactly why they've been commissioned and what they're supposed to be providing. What you often get is a woolly report that, frankly, it feels like a copy and paste job. You can have children with very mild speech and language needs compared to ones that have severe needs, and the provision is still the same. It's a local author based provision. I mean, I've had a tribunal appeal recently where the NHS speech and language therapist wouldn't agree the provision inside the working document, not based on need, but based on the fact that her diary wouldn't accommodate that provision. Now that's completely wrong. That's not the way that this works at all. Provision is based on need. The case law is very clear. The case law is very established about the need for quantified and specified reports. And a lot of the time, those reports are lacking, which then impacts your child ultimately, because the content of the plan is then lacking. And while some parents have the means to correct that by getting their own independent reports, realistically speaking, that shouldn't be the situation. The reports that you have should be fit for purpose, whether they're coming from the LA's educational psychologist, it's coming from the NHS speech and language therapist. They should be. I'm conscious that's an ideal world, but again, just some of the basics of what these reports should look like are very clear to these experts. NHS complaints procedure, though, is a lot more complex, I suppose, than a local authority's one. While the local authority, social services and national health services complaints regulation states very clearly that all responsible bodies have to have them, due to the evolution of the NHS and certain areas having more problems than others, geographically, scandals, all the things I'm related to there, complaint procedures have been constantly reformed. The thing I would say about the NHS complaint procedure is you can normally find them quite easily on each person's website of whatever it is that the service that you're complaining about. The other point is the speech and language therapist, the occupational therapist that you're most likely to run into. If you ask them for it, they're going to have to provide you that complaints procedure, because that's a regulatory requirement. So there is that point that, while I can't give you the definitive of what those timescales are, because they are set out slightly differently for each area of the country, they have to have one. It's normally quite well published. And again, from my experience of using the NHS complaints procedure, while it can take a while to resolve an issue, it does get resolved. That would be my point to it, because the NHS is normally dealing with quite serious issues that are the subject of the complaints overall, such as care that people are receiving in hospitals. So those responses are dealt with. However, if you get to a situation where it's not resolved, NHS England is your next step. Again, NHS England does take a time to resolve its issues, but they do take it seriously. It is, I suppose, is my experience of it. So if you don't get an initial response that you're looking for, particularly with something which, on the grand scheme of things, should be easily corrected and quite easily corrected, NHS England is your next step. However, it is always important to highlight the fact that if you do not get the response you were looking for, that you will be taking it further. So it will be an Ombudsman issue, or it will be a Health and Care Professions Council issue. And again, you can do both at the same time if NHS England don't resolve it. But I have seen some parents recently who have resolved some of their issues. It hasn't been a quick resolution to issues, and a lot of time it comes off the back of an annual review and poor reports that have contributed to that. But again, those reports have come out and they've been substantially better than what they initially came out with in the first draft. Again, shouldn't happen, but that is the situation. So the Parliamentary Health and Service Ombudsman, PHSO, they are, I suppose, two offices combined into one. It comprises of the Parliamentary Commissioner for Administration, which deals with sort of the Parliament side, MPs issues like that. And the Health Service Commissioner, HSC, our focus on this point would be the HSC. They are responsible for considering the complaints about National Health Service, and that the response that you received from either the local team that you complained to or NHS England wasn't decided properly, or poor service, or whatever that issue is. While the Ombudsman and Ombudsmans don't genuinely recommend that an individual is struck off from professional register or fired or that kind of sanction, what Ombudsmans will do, or this particular Ombudsman or other Ombudsmans that interact with professional regulated individuals, they will make a recommendation that that body investigates that individual because they have X amount of concerns. And that is a situation, while I don't wish that on NHS speech and language therapists and occupational therapists, I feel we have got to a point now where the law is very clear on what their reports need to be. And the copy and paste exercise really does need to stop. And it needs to be in relation to the provision that is required to meet somebody's needs, as opposed to just generating reports that don't actually help in any way, shape or form. If you didn't need direct therapy, there'd be no need for a speech and language qualification. And I mean, I think it's covered quite clearly in other webinars by Melinda Erickson about the need for direct therapy and why you spend your time becoming a qualified occupational therapist. So to say that from the usual recommendations that a TA can provide this, or parents, which again is contrary to case law, will provide X amount of support. Yes, obviously parents do want to provide support to their children because that's what parents do. However, the onus cannot be placed on the parent to provide all the provision that a child or young person with SEN requires. That's just a very clear case law point that seems to be missed by a lot of therapists on a regular basis. HCPC, so Health and Care Professions Council, they are the body that oversee speech and language therapists, educational psychologists, social workers, occupational therapists. They set the standards, hold the register. So if you are ever wanting to see whether somebody who's purporting to be an expert is actually an expert, that's the register to check. And they investigate complaints. They also have a standards of conduct, performance and ethics, which, while it is not legislation, it is the guidance by which they expect all of the people who work under their umbrella to adhere to. And I suppose 2 points that parents will want to note in relation to any complaint about lack of specified and quantified reports is 3.4 and 9.1. So 3.4 of the standards and conduct, performance and ethics says you must keep up to date with and follow the law or guidance and other requirements relevant to your practice. 9.1 says you must make sure that your conduct justifies the public trust and confidence in your profession. Now, I've referenced copy and paste more than once in this presentation, and a lot of the time, parents, at the end of the day, parents share information with each other, and you're entitled to do so. If you're in the same area and you happen to put together your child have wildly different SEN needs, and you look at the speech and language reports that you've been provided as an example, a lot of the time those reports can be extremely similar. And again, I would argue that not complying with the various case law and actually producing a report that is based on a child's needs does impact the confidence that parents have in that profession, which again raises issues about should you be professionally regulated by that body. For speech and language therapists, occupational therapists, while you can make a referral straight to the HCPC, they normally will say go through the complaints procedure first before they'll look at a complaint, and they may register it and then pause it while that goes, but they normally want a parent to have gone through and tried to resolve it at a lower level before they get involved. Educational psychologists, social workers, as they work under the LA umbrella, you'll use the LA complaints procedure first for those. But again, those are normally the sort of key four that I think it's about 14 professions under the HCPC, but those are the sort of key four that you'll normally run into that are covered by this organisation. You've then got Secretary of State for Education, or EFSA for academies. Again, a parent does have a right to complain to this organisation, or these organisations, which are technically sort of the same organisation. I've highlighted this before, that these organisations are filled with administrators and not lawyers. Their knowledge of SEN legislation is limited. I referenced it again in a previous presentation that we have seen a complaint before, and it was in relation to a schools matter, but that Section C of that EHC plan contained dyslexia diagnosis, which is just wrong. It shouldn't have been in there. However, they can, Department of Education can step in if it wants to, in relation to LA conduct and school conduct. And also you'll see the improvement notices that are issued to various local authorities across the country in relation to inspections that have happened. It's important to note as well that the decision by the Department of Education isn't always the correct one. Parents assume it sometimes is, and schools from that same perspective sometimes assume it is. I referenced Medway and Queensmead because those are two classic cases that the Department of Education made a decision, and it was overturned by the High Court when judicial review proceedings went in. They are not without fault, and again, a lot of the people who make up the Department of Education have worked inside local authorities. For that point as well, the Ombudsman will, or say the local government Ombudsman, is a lot of time made up of people who have worked in local authorities, and again, that creates its own issues. I'm conscious one of a very well-known local authority officer has recently been made an ombudsman, and you do have to question the appropriateness of that and the level of training or past experience in relation to matters that are being challenged and how they reach their decisions. But just because the Secretary of State makes a decision on a matter doesn't necessarily make it the end of the matter, legally speaking. You still may have potentially grounds to challenge if, and again, a lot of these examples are very parent specific, so it depends on what your particular issue is. But again, it's another avenue to complain if it's local authority that's caused the issue, or ultimately if it's a school that has caused the issue through the way that they have handled things that are outside a disability discrimination claim. Schools complaints procedure. So this isn't just completely focused on the LA and the NHS. A lot of the time schools can be the issue. Section 29(1) of the Education Act 2002 states all maintained schools, maintained nurseries must publish procedures to deal with all complaints related to their school. Academies are actually covered by the Academies Act and the agreements that are reached with Department of Education, but again, they have to have their complaints procedure published as well. The School Information Regulations 2008, since the 1st of September 2016, made it a requirement that maintained schools must publish their complaints procedure on their websites. So you should be able to find that complaints procedure fairly easily. There is a little exemption for community or foundation special schools that are established in hospitals, but it's rare that you run into those kind of situations. But even some of those that are on the exemption, I think just put their complaints procedure online just to make sure it's easy to find. There isn't a one-size-fits-all template for schools complaints. There's a very similar approach that should be taken, which is if you're the subject of the complaint, you shouldn't be the one investigating it, and that creates its own issues there. So depending on what the complaint is, if it's about a head teacher, then the school is going to have to take a slightly different approach to how it investigates that particular complaint. However, a majority of schools do have SEN governors, and I suppose from my experience of SEN governors, a lot of them who take that role normally have a child with SEN themselves. While that's not an absolute, that's not a requirement for the job, it does provide somebody on the governing body that is at least sympathetic or understands the issues that are being experienced by a parent. So again, contact with them alongside a complaint can potentially resolve matters going forward. But always check what your school's complaint procedure is. Hopefully you can work things out without that issue, without needing to get to that point, because ultimately it's a long-term relationship between yourselves and the school. However, you always have to think about what is in the best interests of the child or the young person. If it is a complaint and the school is doing something that they shouldn't be, then as a parent, you're well within your right to complain like any other service that you're provided. You've also got Ofsted, which regulates the majority of schools. I'm not covering independent schools because that's covered by somebody else. However, Ofsted cover the majority of schools in the country. And they obviously do the regular inspections of schools and provide the reports that can be found normally on the school website and on Ofsted's website itself. The issue with Ofsted is, while you can use the complaint procedure from the school, and if you're unhappy with the response, you can potentially go to Ofsted, but they give themselves a very narrow window to investigate complaint procedures. So Ofsted will not consider individual issues about pupils, investigate specific incidents, judge how well a school responded to a complaint, or mediate and resolve disputes between you and the school, or look at complaints if you have another legal route to address it. So that's normally in relation to provision inside of the HC plan, which ultimately sits with the local authority to provide, but sometimes the local authority try and pass the buck onto the school. So you can see that gives Ofsted a very tight window to look at things. It needs to be sort of a broad issue that affects the entirety of the school. However, what Ofsted does do, while they might not potentially investigate a complaint, they will use that to inform future inspections. So repeated complaints by large amounts of parents about a school, Ofsted have historically said that will inform their inspection rota, so that they know where they need to target if they're receiving a large volume of service complaints. So again, it's something to bear in mind if the issue that you have is with a school. So coming on to what I imagine when we get to the question time is going to be a large chunk of the responses, because normally pre-action is the issue to resolve most problems. Pre-action protocol is effectively a letter that is sent from one party to another, which sets out the issues that you want resolved, or else X is going to happen, which X normally is judicial review. The pre-action format is fairly clear, and there are templates for judicial review that are contained in the practice direction that can be found through Googling. And what a pre-action wants to be able to do is to say very clearly to the other party, these are the issues and this is how to resolve it, and here's what I wish to rely on evidence-wise, and here's the means that we can look at to try and resolve the issue before we have to get to the court action itself. In relation to statutory breaches, it's usually a clear yes or no. A lot of the time we're issuing pre-actions on Section 42 breaches, which is a failure to provide the provision, annual review, issues of not reaching a decision, things like that. There is very little negotiation in that. That is a letter with, you have breached X, you need to resolve it within 14 days, sometimes 7, depending on the issue itself, or else it's judicial review. And I suppose the issue with pre-action is it shouldn't be a solicitor-only vehicle. And I mean, it is not a solicitor-only vehicle. You don't have to be a solicitor to issue a pre-action. The problem always comes with pre-action, I see this debate on social media, is essentially litigation is about managing risk. And if you're on the other side of this and working for local authority, which is something we do not do, but if you're on the other side of it, if you receive a letter from a parent, which is in the pre-action format, if it hasn't come from a solicitor, the local authority solicitor is weighing up in their mind, is this person then going to complete the next step if I don't do what they say and issue proceedings? Now, while some local authority solicitors don't take that into account, I know others do, and I've then effectively sent a very similar letter after being instructed, which was then resolved immediately, and there was no defect in what my client initially sent to the local authority. They just ignored it. The other issue is judicial review is different from going into the tribunal. You enter into a cost jurisdiction. So essentially, and I'll cover this on the next slide, winner pays loser. So if you don't get it right in judicial review, there is the potential for a cost order against you, whereas that is extremely unlikely in the tribunal. While it can happen, again, the tribunal doesn't normally make cost awards either way on both sides. So that's the issue with, while you can find you can find what needs to go into a pre-action, issue this yourself, it is incredibly difficult to do this without. These are normally set pieces of work that solicitors will do, and majority of times they will fix the issue that you've got going forward. Again, I'm conscious about financial resources, but that's normally the best investment of somebody's money into doing the pre-action, saying very clearly, this is the breach, this is what you need to do to resolve it and get it done now. You'd be surprised how many times parents come to us and they've been trying to resolve this for months and months. Pre-action goes in, 14 days later, the issue, it's not completely resolved, but it's getting there and the provisions being put in place, or we've got the decision from the annual review that happened 5 months, 8 months earlier. So pre-action is normally the sort of best vehicle for resolving issues. However, if pre-action doesn't resolve the issue, which is in very rare situations, although can happen, you're then into judicial review, which is the threat. I've put there, it's remedy of last resort. It is the nuclear option. You are off to the High Court. You are launching proceedings. You're normally, because it's an education case, putting it in on an urgent basis, or social care issues. It depends on what the matter is. Judicial review is a mechanism by the Administrative Division of the High Court to review the lawfulness of a decision or action made by a public body. There are various requirements of what you have to be in order to have judicial review brought against you, but you can safely conclude that a local authority will always fall under a public body definition and will always be able to have judicial review brought against them. The Administrative Court is a specialist court and deals with, say, a variety of issues. However, administrative law is a fairly complex subject inside itself, and the failure to adhere to statute regulations is an area that they are fully, whether it's education, whether it's housing, that is an issue that they deal with on a daily basis. So they're adequately prepared to deal with the issues that are being raised. The judicial review, while they review the public bodies and decide whether they act lawfully and fairly, it's about it's ultimately about the legality of the decision made by the public body. It's not about the merits of the decision reached. So how was the decision reached, not what was the ultimate answer at the end of the process. Those are two very distinct questions in law, which I've very briefly covered over, and there are massive thick textbooks on those particular subjects. However, did they follow the steps that they needed to in making that decision or comply with their duties, not the subject material of the actual decision itself, I suppose, is the best way to look at it. In any judicial review case, though, the court doesn't substitute their own view. They don't step into that of the decision maker. What they assess is whether that decision made was lawful or not. And then you have various things that can be done about quashing and enforcement and things like that, particularly if provisions not being provided, an order of the court to do that, you then breaching that order, you potentially end up with contempt and other issues there. You don't need to have exhausted the local authority's complaints procedure in order to issue a pre-action protocol. Particularly with education issues, there is a raft of case law that says education is an issue that needs to be dealt with promptly. And again, it's very issue specific on what you do going forward. However, normally the procedure is pre-action is issued. If that is not resolved, then the next step is judicial review. And again, I would always say, take legal advice before you get into issuing proceedings. You can find all the forms online, that's fine, but just be very mindful that you're entering into a cost jurisdiction. And while I've seen various people on social media promote this to parents as an option, just get that check before you do it, and maybe save yourself a headache of issues that are coming later down the line. That's not to discourage people from bringing judicial reviews, because they are raised on a daily basis by people who aren't represented by solicitors, but just think very carefully before you embark on that journey, because it's not an easy one, and it's a very complex one. The procedure rules are different to that of the tribunal. The tribunal will let a lot of things slide, whereas the High Court will potentially strike out your claim if you do get various parts wrong. So that is the point to note about judicial review. It is the nuclear option. It is the remedy of last resort. However, in the times that we've had to get to that point of judicial review, which is very rare with the amount of pre-actions that we issue as a practice, it does resolve the issue. So I'm going to invite James back now. I'm going to take a sip of water because I've been talking for way too long. Who's hopefully going to ask us some of the questions, some of the popular questions, and we'll do that for, actually what time is, about sort of 10 minutes or so, and then we'll sign off and let everyone have a good evening. But yeah, over to you, James.
Yeah, thank you very much for that, Richard. Unsurprisingly, there is many questions to get through, so I will try and get through as many as possible with you. And there is a couple of reoccurring themes, so I'll try and sort of go for those first, and then we'll go through as many as possible. So the first one is from Stephanie, and Stephanie asks, what steps can you take if the LA don't follow the correct procedure for the HCP assessment process if you've already complained to the LA and got no remedy?
So it very specifically depends on what happened during the HC needs assessment process. Normally, and I'm taking a guess, this is probably something to do with experts, and those experts were not assessing or things like that. Again, I suppose if you're outside potential complaint territory, you've already exhausted that, you're probably moving into a pre-action situation. There's various sort of permutations to that question. I think if you're in a timescale issue, then you're definitely in a pre-action situation. But so that one's a very specific point. But it's normally experts, or it's the time that's taken to do it. I can't think of any other sort of main issue. So if it's experts and they've done something or not done something, you potentially pre-action or professional complaint, which I've signposted earlier in the presentation. If it's timeframes, it's definitely pre-action, because we hear it all the time. People are at 40 weeks and a decision hasn't been issued about whether they're going to have an assessment, or a plan hasn't been issued. And you think, well, that the timescales are very, very clear.
Yeah, I think the most common one is the timescales, of course. I think that, like you said, that's the one where you go straight to pre-action. That's easy to resolve. The second question up is, and I think you touched on this in the PowerPoint a little bit. So Michelle asked, why won't the LGO consider time out of school or without education whilst on the tribunal? Essentially, why does the tribunal not address the lost education that occurs? So I think really the sort of question is, why aren't the LGO sort of dealing with matters whilst tribunals are ongoing? So
I did cover it, but I'll just sort of recap briefly. I'm not going to butcher the Latin for whatever which I believe my colleague Nicole is in the background, who can always tell me what the Latin for it is. I'm not going to put it on the spot right now. However, it's about redeciding a decision that has already been made by a judge. It's a very set legal principle, and the Ombudsman has always taken that view that if the tribunal reaches a decision, that decision shouldn't be examined in any way. However, what the Ombudsman normally fails to address is the conduct of the local authority officers involved leading up to that decision don't actually impact that decision in any way. The tribunal don't take that into account unless it's a barring or strikeout application. Therefore, to examine what the local authority officers did during the appeal doesn't breach that principle. The Ombudsman is not superseding its view over the top of the tribunal judge in any way, which is normally where the challenge comes. I suppose the out of education point, yes, the Ombudsman should be investigating that, and that is always my view. They sometimes loop that into that's the tribunal issue, whereas the tribunal don't have the power to deal with that issue. They're just dealing normally with what are the needs, what's the provision, what's the school placement, or it's cease to maintain. They're dealing with that fixed issue. So for everything the tribunal doesn't deal with, the ombudsman should be. And my hope is, as one judicial review happens and that creates a bit of case law, it then cements the principle in place that what the ombudsman should be doing and what it shouldn't be doing. And I think that's a case that for too long they've relied on sort of that legal principle of we're not getting involved in something where a judge has got involved when realistically they could.
Yeah. And sort of touching on the LGO a little bit more, this one sort of leads on to it. Once an LGO has given a decision, who then makes sure they follow through? So what can you do if the LGO decision is issued, but the LA does nothing, for example?
So, I mean, this has happened. I was trying to think which local authority it is. There was one of the local authorities, I'm going to say up north again, which is a wide stretch of the country, that was looking at potentially refusing to implement an LGO decision. I mean, if you get into that situation, you're into pre-action judicial review, because ultimately a failure to follow a local government ombudsman decision is grounds for irrationality. They are the ones who supersede the statutory powers are fairly clear. So while the ombudsman won't follow up their own decision and won't enforce their own decision, a parent will have a right to enforce that decision. Again, you're into pre-action and judicial review. It's highly unlikely, it's very extreme, that a local authority will refuse to agree the decision of a government ombudsman. Sometimes you get a local councillor who thinks they're being very clever by avoiding it, but a letter to a solicitor of that local authority will normally resolve those kind of issues.
Yeah. This one's touching on mediation, and Carleen asks, and I don't think you'll have the statistics to hand because I don't know if they exist, but statistically, how often does mediation resolve an issue without the need to appeal to tribunal? I have heard people talk about it. This is just a pointless step. So really, your sort of view on mediation, I guess.
I mean, I'm not a fan. I will be very honest. There's very limited situations where I think mediation works. If the local authority wanted to make the decision in the first instance, they would have made the decision. There are limited successes that parents have. I suppose our perspective is, while I don't have any hard and fast statistics, and if I tried to pull something out of the air, it wouldn't work. I suppose we have a skewed point of it, of the fact that when parents come to us, they've already exhausted that point, or they've been round, I suppose, the merry-go-round many times before. And realistically speaking, getting into the tribunal jurisdiction is the key one for us, because ultimately that's going to be the quickest way to resolve the majority of issues in our view. So that skews our opinion of it. But again, some parents have had successes before, and I can't, that's fantastic if you can avoid having to get into appeal. No parent wants to go through the appeal process ever. It's not something they wake up one morning and think, this is what I'm going to do for fun for the next 6 months. So if mediation does resolve it, however, a parent will know their local authority better than anybody else and the people that they're normally dealing with. And if they've done it many times before and not achieved the result, then I suppose those past actions will inform the future. So I suppose that's my view on mediation. Yeah,
I must say I do also share that view, that's for sure. I think many of us do. These questions, there's a sort of theme in these questions, which are about reports and about having to sort of carry out your own private reports in order to get the specification and quantification that's needed. But a lot of sort of people watching are asking, is there any way to sort of go down the LA complaints route or the LGO route to sort of get reimbursement for those reports following an appeal, or sort of outside an appeal route, I guess?
I mean, you can make a complaint, but in reality, I've never seen it. I've never seen it done. That's not to say that it hasn't happened. However, what will normally be put forward by the Ombudsman is the defect in the report didn't necessitate the fact that you needed to get the independent expert evidence, and you could have taken other steps and things like that. I mean, that argument's made in tribunal proceedings all the time, that we shouldn't have to get the reports sometimes from independent experts to correct the plan, and therefore the tribunal should be awarding costs. However, the tribunal doesn't take that view, and I would be surprised if the Ombudsman did take that view when you're looking at just broader issues of children who are out of education or have missed, actually just take therapies, who have missed weeks, months of therapies, the nominal amount that is given back by the Ombudsman because of what I would say is a lack of understanding about how this actually impacts children with SEN, it's extremely rare. I think the best you'll probably achieve is by going to that person's professional body and trying to stop that issue from happening again, as opposed to actually getting a cost reward to try and put you back in the position you were in, because it's just an unlikely event in my view. Again, I don't want to stop anyone from trying, and if you do get successes on it, then fantastic, please share that with us, but it's highly unlikely the Ombudsman will take that view and support that.
Yes, it's probably not the sort of answer they wanted to hear, but it's unfortunately it's the reality of it. But I mean, that leads on to the sort of next question, which is sort of about accountability for local authorities, which I know you're sort of quite interested in, Richard. Khalid asked, with regards to a breach, what does this actually translate to in terms of penalties to local authority? So is there any penalties for local authority breaching its duties?
In reality, no. I suppose it'd be, again, really honest answer to a really good question. Because people who work for local authorities are not normally regulated individuals. I mean case officers, not EPs and social workers. The people who actually make the decisions, because you lack that body that you have to report to professional ethics wise, that creates the issue of you can carry on doing it as one complaint is being resolved by the Ombudsman and practices are being reviewed and things like that. The merry-go continues round, that decision is continually being reached. So I suppose no, there isn't a consequence for the officers who are making these decisions. I suppose that would be the point that I would make in relation to SEN reforms. It's not actually about the law that needs to change. It's about the accountability and having mechanisms in place for when you commit an unlawful act, that there is some kind of penalty, because ultimately in any other line of work, you're looking at gross misconduct or at least a disciplinary type offence that doesn't happen. And it seems to be only when an error, breach or an unlawful act happens that is such severity that causes enough harm or media attention, does things seem to happen inside a local authority. But again, it's not normally the people who have made the decision, it's normally somebody higher up in the authority that then walks away. So being incredibly cynical and jaded about local authorities, that is the problem with them. That accountability point doesn't seem to ever be addressed, and it continues the merry-go-round of poor decision making and unlawful decision making.
Yeah, no, I certainly agree. I mean, I think we've got time for one last question, because you've been speaking for a while now, Richard, so I'll let you off the hook there. But it's on the sort of final topic of your webinar as such, and it's a question from Marsha. My daughter's school are not providing provision in section F. Should I complain / notify the local authority or approach the school first? I'm about to submit an SEND 35 to lodge a BNF appeal.
Well, I was going to say, again, I don't know the exact specifics there, but if it's provision not being delivered, it's a section 42 breach. If that provision is properly quantified and specified in the plan, TA hours, whatever it is, the duty is for the local authority to provide that. So local authority is your first point of call. I mean, you can engage the school in it, but it's technically not, while they've got to use best endeavours to provide that provision. If a lot of the time it's a case of lack of funding, the local authority needs to resolve that and should be made aware. I mean, this is again, depends on the content of the HC plan, but this is a classic one for pre-action. Ultimately, a letter to the local authority to say you are in breach of section 42 in relation to X provision because it's not being provided. That's the normal step we take. If you're appealing BNF because you need more provision, then fine. But if you're appealing BNF because they're not providing the provision, then that's not the appropriate step. The appropriate step is getting the local authority to ensure that that provision is being put in place.
Brilliant. So yeah, like I said, I think that's all we've got some time for tonight. It's now sort of over 8 o'clock, 5 past 8. So I appreciate there are some questions that we haven't got to. But if you do have sort of specific questions, do feel free to get in touch, of course, and we'll be happy to go through some specific questions at a later point. But thank you very much for watching and listening. There are still additional webinars coming up for you all to sort of get involved in. On this Thursday at the same time, so 7 till 8 o'clock, we've got Kathleen Long, an independent social worker, who's going to be talking about when parents with children with SEND are accused of fabricating or inducing their child's illness. So please do tune in for that, because that is a live webinar as well. And then the last one of the webinar series is actually myself next week at Tuesday, and again at the same time, and I'll be talking with things transport and what you can do about when things go wrong and what your entitlement actually is. So thank you very much, Richard, and thank you very much everyone for listening. We'll see you again on Thursday.
Very much for tuning in. Have a good evening.